to introduce our speaker, our first speaker, Michael Burnett. He is basically in the board, in the EPPL board since its beginning, since 2007, so almost 20 years. I'm really glad that we can benefit from his experience on this rather big endeavor that the EU is onboarding, the revision of the EU Public Procurement Directives. He is he's also a member of the audit committee of the member Solihull Metropolitan Council in the United Kingdom, and he in this council they oversee public procurement activities, among other things. He's very engaged in complex procurements, including competitive dialogue and competitive procedure with negotiations. He is also part of the European Commission Stakeholder Expert Group, and since 2021 he's part of the OECD's Auditors Alliance. Having said that, I'm very excited to hear about his thoughts and his views on the upcoming revision of the EU Public Procurement Directives. Thank you.
Thank you very much, Desiree, for that very kind introduction. And I've had the privilege to be involved with EU public procurement since 1990. In different roles. My first role was to work for a service provider providing services to a public authority, and simply since then it's moved on to the audit of public procurements and helping public authorities design and implement them. My particular interest in procurement audit stems from the fact that for more than 12 years I've been working with the European Court of Auditors on this subject. And also I've had the privilege, I lived for 15 years in the Netherlands, which gave me the chance to do business and procurement in just about every EU member state and candidate country. You might wonder, though, why somebody who is from a country that's no longer in the EU is passionately interested in this subject. Well, apart from the fact that when the EU referendum was held after it had been announced, I produced a car sticker which said, "Don't blame me, I voted Remain." And secondly, also importantly, though it isn't necessarily obvious from the presentation, my wife and my son are both EU citizens, so I have an interest, a clear interest in the future workings of the EU. So, what have we? My job today is to sort of, in a sense, give an introduction to the process and share some of my specific thoughts, because the three presentations on innovation by European and environmental and social procurement are all key issues which the following speakers will go into in detail. I've summarised here the scope and timing of the review. It covers the three core directives. Although, interestingly, it doesn't include the remedies directive, though, although, as you know, the remedies directives provisions are incorporated into the concessions directive. There's a lot of interest in this subject, 2 rounds of consultation by the Commission and the Commission's evaluation, and the Commission have consulted with various expert groups and with member states. So what are the Commission's aims set out for the revised legal framework? Firstly, making public investment more efficient, which is very important because of the share of total GDP that public procurement represents. Secondly, given the competitive nature of the world, the importance of strengthening Europe's economic security and sovereignty. And as Desiree said, Sarah Skernmakers will be talking in more detail about this subject later on. And thirdly, since the last directives were formulated, there's been a lot of new EU strategic policies, and compared to the revision of leading up to the 2014 directives, in which I was also involved, as Desiree mentioned, as a member of the Stakeholder expert group on public procurement, much more alignment to strategic policies such as green and social and innovation procurement. So what has the Commission found to be the challenges? Part of these came from the review in 2021 of the implementation of national procurement policies. Clearly, nobody has ever pretended that public procurement is easy to do well, and secondly, to ensure two key objectives of cross-border market access and dealing with barriers both within the EU and imbalances in international market access. And we'll see later on the legislative developments that have occurred in order to address this issue. There are clearly differences in capability amongst contracting authorities, and particularly the issue of learning from others with poor quality data and data gaps, which are very important to ensuring that procurements achieve the objectives that they are intended to achieve. You would expect there to be uneven capacities in governance because of the different size of awarding bodies. And of course, it raises the question of whether or not more procurement should be done by central purchasing bodies. So what are the main things that have happened since the 2014 directives? The Commission has come up with 4 different guidance documents that are mentioned there on green, social, and innovation procurement, which is, as Desiree said, will be dealt with in more detail by the later speakers. As I mentioned, a number of the challenges in national procurement policies were identified in this Commission report of 2021. Also very important was a report in 2023 by the European Court of Auditors on public procurement in the EU, which highlighted challenges particularly about the promotion of competition. As regards enhanced cooperation on public procurement within the EU, again, addressing the issue of learning from others, the creation of the public buyers community, and the Public Procurement Data Space. And also an important initiative by the Commission to improve the quality of public procurement delivery, the ProcureComp initiative to professionalise public procurement. Then we had the Commission's report somewhat later than originally thought on the functioning of the Concessions Directive, particularly highlighting the issue, many issues, including the issue of the classification of transactions as concessions or public contracts. there is a question which we come to later on as to whether indeed concessions should be awarded by the same procedures as public contracts, given the similarity of the principles that underlie the Concessions Directive and the other directives, and whether or not the value of those contracts and the question of transfer of operating risk justify different procedures. There's been various external studies on the directives for the Commission in the context of this review on the subjects that I've listed there, and it's very good that we have Roberto Carranza with us today, because he was the author of one of these reports on behalf of the Commission. A couple of other high-level reports on the directives. The report by Enrico Letta, former Italian Prime Minister and President of the Jacques Delors Institute, and he raised the issue which will need to be addressed as to whether the new legislative framework should be in the format of regulations or in the format of directives. There are the argument being that regulations will create a greater degree of consistency in application. And then the report by the another former Italian Prime Minister and former President of the European Central Bank, Mario Draghi. Neither of these reports are specifically about public procurement, but because public procurement is a core element of the internal market, they are relevant to it. But then, as I mentioned, the question of made in Europe and by European economic security, particularly in a world of greater uncertainty and conflict. Again, as I mentioned, what is needed is to make sure that Europe has security of the key products that it needs and the ICT services. There have also been a number of significant legislative developments. Anti-corruption is moving up the agenda. Of course, it is there as one of the potential exclusion grounds, but the Commission has been addressing this with a notice on fighting collusion and a draft directive that's going through the legislative process. As regards equality between the EU and third countries, by which, as you know, we don't just mean the EU and the EEA, we mean any country that's not part of the World Trade Organization's GPA, or with whom the EU has a trade agreement involving procurement. There's the International Procurement Instrument, which is, and the Foreign Subsidies Regulation, both of which are potentially designed to address access to third markets by placing constraints, including potential scoring adjustments or exclusions from countries which don't give appropriate access to EU companies, or where there are levels of subsidy for offers for contracts within the EU. Moving on, you have the Corporate Sustainability Due Diligence Directive, which addresses within the EU HR and environmental impact of operations, and identify mitigating measures. Of course, we have the Artificial Intelligence Act, fundamental to many aspects of the delivery of goods and services. And the latest is a draft regulation that came out recently, which will lead to what is called the Industrial Accelerator Act. In other words, something which will aim to accelerate industrial capacity within the EU and decarbonisation. So those are some of the legislative developments. That's not the end of them. There's of course, you have the General Data Protection Regulation and 4 specific regulations that relate to environmental issues, all of which need to be taken into account in public procurements. So, and in addition to that, there's been social legislation which has an impact on public procurement relating to workers' rights, working hours, and social exclusion. So the general point to be made is that other legislative developments have become much more linked to public procurement than was perhaps the case in the past. I had the opportunity to write my latest article on this subject in the journal last year, and I'm going to spend a bit of time talking about my thoughts on these specific amendments. But I mentioned already the question of whether the new rules should be directives or regulations, or whether the remedies directive should be incorporated into the core directives. I suppose there is also the question as to whether the changes should be made by amending the existing directives or incorporating the concessions contracts into the Public Contracts Directive. When I gave evidence to it to the Internal Market Committee in 2012, I raised questions as to whether concession contracts were in fact that different, given that the same principles need to apply to them, and does the length of contract or the value or the transfer of operating risk really justify a separate directive, particularly given the flexibility that exists within the Public Procurement Directive in relation to the use of dialogue and negotiation. The fourth issue is, and different opinions were expressed in the consultation, should the rules be more or less prescriptive? In other words, in order to underline the importance given to environmental and social legislation, should these criteria and a waiting for them be mandatory? On the other hand, this would raise the question of to what extent this may negatively impact the ability of small and medium-sized enterprises to win contracts, which is another important policy agenda item for the EU. So let's look at some of the specific amendments which I think might be introduced. I'm going to concentrate only on the Public Contracts Directive, although clearly there is a case for some changes also, and I mentioned these in my article to the Utilities and the Concessions Directive. Article 24 could arguably be extended explicitly to refer to senior officials and political leaders. It refers only to those involved in the conduct of the procurement, whereas we know that conflicts of interest influencing procurements can also arise for others, as senior officials, political leaders, non-executive directors. There's an argument for amending Articles 27 to 32 for tenderers to declare that expressions of interest and tenders have been prepared independently. Again, of course, there is the anti-collusion provision in Article 57.4, which is a potential ground for exclusion. But again, if these declarations have to be made, then that could underpin the ability to exclude. Article 29.4, the competitive procedure with negotiation allows for the acceptance of initial tenders where without negotiation, where the awarding body has said that it gives itself the power to do so. However, if you do that and there is no pre-initial tender negotiation, and the directive neither forbids or prevents that, forbids or requires that, it raises the question about, firstly, whether there was a genuine justification for the use of CPN, and secondly, whether or not there might have been a favoured insider. The idea of participating in procurements, particularly those that are time-consuming, like competitive dialogue and CPN, are linked to whether people think they're going to win. And if they think there is a favoured insider, then they are not so likely to win. And that's why there's an argument for amending Article 29.4. Moving on, Article 30, subsection 8 allows for prizes and payments. Interestingly, it's only in the competitive dialogue, the competitive dialogue clause. It's not referred to in any other procedure, including CPN. There's an argument for saying that there needs to be value for money for this, perhaps my argument would be it should be amended to refer to demonstrable value for money, perhaps where proposed solutions, as they sometimes do in dialogue or negotiation, need to be tested before acceptance. Direct awards are an important area of abuse in public procurement, and therefore my argument is that the directive should be amended to require independent assessment of the justification, e.g. by auditors and regulators. One of the things that I do when I work with the European Court of Auditors is underline the idea for auditors that they shouldn't just turn up after the car crash, or in other words, when the contract's been awarded. And involvement at an earlier stage could include being part of the process of confirming whether or not justification for direct awards is appropriate. Article 33 relates to framework agreements, and there's an argument both to improve the planning for contracting authorities and the preparation by the members of the framework, if there are going to be a mini competitions, to know approximately when they should be ready to make those bids. And some potential changes to Article 57. There's an argument for making all of the optional exclusions mandatory to create consistency across the EU, and also to add as a mandatory exclusion basis breach of the EU's AI regulation. Another potential change to Article 57 could be to add an obligation for member states to maintain and publish a list of entities excluded from public contracts under this article. Again, And this is something which is in my view, a positive development in the new UK Procurement Act 2023, which creates the concept of debarment lists. Also, that would be relevant to the application of the exclusion ground for significant and persistent deficiencies. So, adding the AI competence to the technical capability criteria in Article 58, again, underlines the importance of how AI increasingly applies to the delivery of goods and services. Moving forward to Article 67, in the Public Contracts Directive, there is the option where award criteria can't be weighted to allow for award criteria to be set in descending order. Well, a couple of things. Firstly, it's extremely difficult in practice to actually evaluate tenders where you use descending order. And frankly, if you can't, this might sound a bit direct, but frankly, if you can't objectively weight the evaluation criteria, it raises questions about whether the awarding body actually knows what its priorities are in the award of the contract. Article 69, there's an argument for adding numerical guidance of examples of abnormally low tenders, although this may be part of what we come to later on, the suggestion of more interpretive guidance. Article 72 is currently called contract modification, but there's an argument for renaming it contract execution and requiring both a value for money and a legal justification for the modifications and for the publication of the justification. Secondly, setting a time limit, except in exceptional force majeure circumstances like war or climate emergency, before which modifications can happen for any reason. Because as many of us will know, abnormally low tenders are often followed by quick requests for modification of tenders. The third point here is the fact that while contracting authorities probably do set KPIs for all contracts, there's an argument for having them published and publishing annual information on performance against them, again, to build up public confidence in the delivery of contracts and to confirm that the awarding body is actually managing them. These requirements of publishing KPIs for higher value contracts and performance against them also comes from the UK Procurement Act, where these are a requirement for contracts with a value of more than £5 million sterling. Again, this provision would assist with the question of addressing assessment of significant and persistent deficiencies. Moving on to the final two specific amendments, the directives do not say that goods, works and services have to be procured through a procurement process. Direct delivery is permitted. So there's an argument for amending Article 84, subsection 2, to require the publication of an impact assessment as to why there is a procurement rather than direct delivery. And Secondly, to justify the choice of procedure, even when the open or restricted procedure is used. This isn't a revision of the articles which allow for the Article 26, which allows for the use of these procedures, but the choice between them and the design of the procedure is arguably something which should be justified by in terms of decisions needing to be justified by Article 84.2 and Recital 126. So what are the next steps? The Commission is about to publish its draft proposals for the legal framework in the second quarter of this year, and then it will go through the normal legislative process of scrutiny by the Parliament and the Council, which is likely to take at least a couple of years, and then transposition by member states if via directives, or practical time for implementation if it's a regulation. And so, what other options? A few further final thoughts as to what might be useful in future for the effective application of the directives. Firstly, an annual Commission summary of the key lessons from the latest EU and national case law. They include some of this in some of the evaluation related to the formulation of these directives. Secondly, an annual Commission's summary of contract awards by analysis by number and value, things like who wins within or outside the EU, number of direct awards, number awarded by the basis of price and quality. There's a whole series of areas of interpretive guidance. Thirdly, as you know, the Defence and Security Procurement Directive is currently in the process of revision, and there's an argument for linking the two to ensure consistency. And finally, I mentioned interpretive guidance on key aspects of contract award and contract execution. Particularly, there's a strong case for guidance on the conduct of dialogue and negotiation and how to conduct effective contract management, which needs to start at an early stage. So those are my thoughts, overview thoughts on the revision of the directives, and happy, of course, I'll be staying throughout the entire session. So if you have a question later on for me, please feel free to ask it. Thank you, Desiree.
Thank you very, very much, Michael. That was a very nice overview over the amendments coming up. I have a lot of questions, and I believe so do have many of our participants. I would like to read two of the questions that we received. Maybe you can answer those, and with the permission of Björn, I would like to maybe take 5 or 7 minutes to answer those questions before we then go into the coffee break. So the first question is from Camilla Thompson. She's asking, in the context of the upcoming changes to public procurement legislation, will there be greater flexibility to conduct negotiations within a single-stage tender procedure without first having to run a separate pre-qualification or two-step process?
Well, it's just to be clear, she is talking about the open where the open procedure is used. A single stage procurement, is she referring to the open procedure?
She's not specifying that. Maybe you can answer it for
in the chat. Yes.
Yeah. Well, certainly certainly when I even before the 2004 directives, there was something between pre-market consultation and, in the case of the restricted procedure, discussions with those shortlisted before the information to tender was published. And as I say, that was at that time that our UK law firm certainly thought the second was permitted. And of course, there is always the opportunity for, and probably desirably, for pre-market consultation prior to advertisement. In fact, there's an argument which some people argued in the consultation that market consultation should be obligatory for certain contracts.
Very good. I hope this answers our question. We have a second one already. Whether there are discussions about reducing the number of procedures, or whether there are discussions to introduce even more or new simplified procedures.
I didn't see. Oh,
that's a new question.
Yes, in my review of the consultations, I didn't see any specific reference to that. It was more about the implementation of the procedures. What I would say is that, having been extensively involved in the both competitive dialogue and the competitive procedure with negotiation, in practical terms, they are run in the same way. And I recall from the process by which, when the 2014 directives were being formulated, some people argued for there to be no need for the competitive procedure with negotiation, rather than as well as competitive dialogue. However, that was essentially a political decision, because if you look at the usage of CPN or the former negotiated procedure and competitive dialogue, the significant variation between the application of those two procedures in different countries. So I think, yes, my argument would be that there is a clear case for simply having one procedure, and that's what's happened in the new UK Procurement Act. There's something called the competitive flexible procedure, which in effect combines the key aspects of sets out the key aspects of competitive dialogue. So my argument would be you could probably reduce it by not having the competitive procedure with negotiation. But there wasn't a lot of comment on that in the consultation.
Yeah, I think it is really also a need to simplify, despite the many changes that have been proposed. And now we have a question that goes a little bit into third country access from Pedro Camero. He's asking what can be expected in the directives in terms of market access for non-EEA economic operators.
There will, I think, we have the International Procurement Agreement and the Foreign Subsidies Regulation, and it could be that some of those provisions, certainly anything in the new directive, will have to be consistent with those two legislative acts, and whether or not the revision simply says the selection of candidates and tenders has to comply with the IPI or the FSR. That would probably be the simplest way of doing it.
Thank you very much. I think that's, we all know the cases, Colin and Qingdao, and so maybe some clarification on third country access is maybe desired by those countries. We have another question from Suala Varmate. She's asking, could you please clarify the intended scope of the publication regarding contract administration? Is this meant to serve as an internal compliance record for the agency, or is it intended to proactive disclosure to the general public?
So the
scope of the publication regarding contract administration, is she modification? Probably she means.
Yes. Well, again, it could be either. My argument would be that in the context of what I was mentioning earlier on, there is a need for interpretive guidance at EU level on how contract modifications are considered. I mean, there is a wide view that Article 72 is not one of the best bits of drafted legislation in the EU, and certainly if there needs to be interpretive guidance on the application of the first of the grounds of review permitted. So I think this is probably best dealt with by interpretive communication. But as I say, I think that the Commission should indeed start publishing a lot more interpretive communications on the application of the directives, and indeed, as I mentioned, an annual summary of the impact of the case law in the past year on how the directive should be applied.
Very good, thank you for that. We have yet another question from the audience, namely from Eva Kostroniska. She's asking, will there be a change to the or equivalent rule for each use of the trademark, or when the standard is cited?
I certainly don't think that the or equivalent provision will disappear, because otherwise it would be restrictive on who might be able to win contracts. My view is that it would be helpful if the Commission produced some interpretive guidance on what constituted or equivalent. In other words, what actually had to be there for something to be qualified as equivalent. But I can't see that the or equivalent will be removed.
Thank you so much. If I may jump in with one question, I was also wondering whether they have been discussions on post-award transparency other than the KPIs, like in terms of publication of contracts, contract registers, or even performance indicator at the end of a contract.
Well, as regards what you publish, there's this debate about whether publication encourages transparency or breaches the confidentiality requirements that are also in the directives. And certainly the case law of the Court of Justice has ruled that you don't have to publish all of the offers. There's an argument certainly for some clarification about what needs to be published to demonstrate to losing bidders whether or not why they lost. As I say, what you don't want is a situation where challenges are launched in order to effectively gain access to the technical skills and abilities of other suppliers.
Thank you so much. I take one last question, and then I would say let's go into the coffee break. So a lot of questions about the revisions. It is a question from Nuno Silva. He is asking, the majority of public procurement, likely more than 70%, consists of below threshold purchases, which are therefore not mandatorily subject to competitive tendering. Is it reasonable to expect forthcoming regulation aimed at maximizing the use of competitive mechanisms for these below threshold purchases, while ensuring that the procedures remain simpler than the open procedure?
I don't expect that the new directives will explicitly specify how to conduct below threshold procurements. And again, I come back to interpreting the importance of there being more interpretive guidance. It does raise the question about the thresholds, though, and how they are revised. But no, I think that I don't expect that the new directives will deal in a lot of detail with below threshold procurements. But again, I think there's a strong case for interpretive guidance by the Commission. I mean, I suppose this, as I've mentioned, interpretive guidance by the Commission many times. I think that this is it will be challenging for them, but very, very important in the better application of the directives. And below threshold could be one example.
Thank you very much. And I just have one burning question, namely, what is your personal opinion on the debate regulation versus directive? And with that, I will let you go.
Thank you. My view is that it will probably be directives because public procurement is such a sensitive and political issue across the EU, and I can't see member states agreeing to a regulation, and certainly I would envisage that it will take much longer than foreseen to actually get agreement on a regulation. So if I had to make a prediction, I would predict it will probably end up as one or three directives.
Thank you very much.